respondent. The matter stands adjourned today. List
on 25th of August, my lord.
okay, list on 25th August 2026. Okay.
25th. Highly applied.
May I please the lordship? I beg to mention item number 22 to 26. Senior advocate landed Mr. Diganta Das is appearing in this matter, so it's difficult.
Yes.
22 to 26, madam.
Yes.
Senior advocate Mr. Diganta Das is appearing in this matter.
Okay. 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 List this matters before any other bench without one of us. And then Mrs. Justice. Let's come.
Deeply obliged.
May I please lordship?
Yes.
Like to mention item number 5. Yesterday I had submitted.
Item number
5.
5 is 2019. You have to wait. 19 till 21. We are not adjourning any matters without looking at the records.
May I please the lordship? Your lordship, I beg to mention item number 12 of today's daily news. Mrs. F. Begum was about to appear, your lordship, but she's not well. She's suffering from viral fever.
Okay. 12. What is the representative on the prayer made by non-counsel for the petitioner? List after 2 weeks.
Deeply obliged, your lordship.
May it please, madam. Allowed with the consent of the others, I beg to mention item number 44 of today's daily list. Adjournment slip was circulated yesterday, madam.
Adjourns. Okay, 44.
Yeah,
Your prayer is on behalf of?
I'm appearing on behalf of Mr. I. Chaudhary.
Okay. 44.
He has informed me yesterday.
Okay. Both sides are represented. On the prayer made on behalf of the learned counsel for the respondents, the matter stands adjourned today. List on
May I pray for 10th of August?
10th of August. Okay. Oh, 10th of August.
Obliged.
Your lordship. Your lordship, I beg to mention item number 34 for adjournment as the conducting counsel Mr. Anish Rodaway is out of station.
24.
34.
But this is a criminal reputation. What is the matter about? 24. Oh, acha, that you have instructions. Just wait. We'll because this is a criminal reputation and the instructions have come.
Okay.
Please wait till the matter is called.
May I please, your lordship? I beg to mention item number 10, lordship. My senior as shown has sustained spinal injury, lordship. Doctor advised him 3 months bed rest, lordship.
10.
10, item 10, lordship.
Okay. Book says a representative. It is submitted that the learned counsel for the learned counsel holding the brief for the petitioner has suffered an accident and has suffered spinal injury and is advised 3 months bed rest. So accordingly, matter stands adjourned today. List. But we'll list after 4 weeks, then we'll see. You can't list it after 3 months. Give a date after 4 weeks. Okay.
No
Yes.
problem.
May please, your lordship. I beg to mention item number 30, your lordship. Though it is a 2021 matter, the arguing counsel, Mr. B. Retto, was supposed to argue the matter today through VC, but due to some personal difficulty, he is unable to appear before this.
No, you have to wait till we call the matter. Till
Deeply
21, we are not adjourning at this case.
Deeply obliged.
May I please, your lordship, I beg to mention item number 16 and 29.
Item?
16 and 29. This matter kindly.
Item 16.
And 29. 16 and 29.
16 and 20.
29.
29. 29, you'll have to wait. 16, we'll adjourn.
My lordship,
16.
my senior Mr. alia appointed as an assistant public
No,
prosecutor.
but 20 and 21, we are not adjourning. We'll have to look at the records and then pass orders. We'll have to wait. Item 16, both sides are represented on the prayer made by learned counsel for the petitioner. List after 4 weeks. That you'll have to wait.
May it please your lordships. I beg to mention item 4, your lordships.
4 is, no, you'll have to wait.
Mentioned.
For motion, item 1.
May it please your lordship. Your lordship may kindly pass over the matter for the day as my
No,
senior
no,
is
no.
out of station as his
No,
mother is
that's,
unwell.
that's not possible. 2019 matters, we are not adjourning.
My learned counsel's mother is unwell. Sir. May fix any date, lordship.
Next week, if there are 3 lawyers, if there's some difficulty, another may take it up. Both sides are represented. Only prayer for adjournment is made on the ground that the mother of the learned counsel holding the brief is unwell. To stop. Matter is adjourned today. List on, give a date after a week.
Oh, bibliography.
Item 2.
Lordship, item 2 may be taken up after some time. Mr. Pine would be coming, lordship.
Lordship, may I pray to take it up on some other days, because Lordship, in the meantime, the LCR of the brother has come. So I'll go through the records of the brother also, Lordship. On last occasion, brother was declared Indian, Lordship. On last occasion, on 23/6/2026, your Lordship is directed to call for the TCR, Lordship. Because this is showing 2 TCR.
Daniel Shirley Roy.
So if your Lordship permit me, I'll go through the TCR. Maybe taken tomorrow or day after tomorrow, Lordship. Or at 2 PM, Lordship. At 2 PM. Page 38, annexure 13 is the judgment passed in case of the brother, Lordship. After going through this judgment,
Okay.
the Lordship was pleased to call for the TCR of this record also.
Okay, we'll take it up on Monday then.
Lord,
Both sides are represented. On the prayer made by learned counsel for the petitioner, list the matter on 3/8/2026.
Monday, third,
Lordship,
third, third hour. Lordship, I may be allowed to
Just
go
just
through
on,
the TCR.
so in the admission column.
May I go through the TCR?
Yes, yes.
Obliged, Lord.
Item 3 for motion.
May please, your lordship.
Yes.
Lordship, in this case, lordship petitioner declare for the stop 71, lordship. Impugned opinion is page 27.
Yes.
Impugned opinion is my lordship, my page 27, lordship.
Yes.
Lordship, petitioner, in this case, petitioner subject the brutalist of 1965, is page 12, my lord. It is the father of the petitioner, my lord. Page 12,
Which page?
page 12, on to. Virendra Sen. Is the father of the petitioner, lordship.
Yes.
Then upon lordship, NRC voter details in the year of 1965 in the name of the father of the petitioner, my lord Virendra Sen. After that, my lord, school certificate issued by the headmaster, my lord, in favor of the petitioner, uh, my lord, is page 15, my lord.
But
Aurobindo-
headmaster did not come and depose.
My lord, no, my lord, he's not come, my lord.
Then there's no link. There's no link between you and your projected parents.
Yes, my lord. This document is exhibited but not proved by issuing authority. This is the only link document between the father and the proceeding, my lord.
And after this 65, what happened to your father or parents?
My lord,
There's nothing is, there's no evidence to that effect also.
my lord, nothing is discussed with the WS also, my lord. No discussion with the evidences also, my lord.
Pardon me? Please repeat again.
My lord, written statement, my lord, page, my lord, 20, my lord, may I read the written statement, my lord? Page 20, written statement of the opposite party. That the opposite party, Smith Shobha Vishwas, wife of Sri Bimal Vishwas and the daughter of Virendra Sen, is a permanent resident of village Sarapur Gaon under PS Tezpur district, Sonitpur, Assam, and as an Indian citizen by birth. That the above case is not at all maintainable in the present form under the provision of the Pioneers Act 1946 under
No, but
the
your father's presence is not there thereafter.
my lord,
After 65, what happened to your parents is not known. In your evidence on affidavit,
no evidence,
Page-
father
page
evidence.
26, you refer to a plot of land purchased in 69. There's no record of that.
No record, no document was submitted. My lord. Just
Then-
no document was submitted.
There's no link.
But mentioned, he has purchased a plot of land, but the land document was not submitted in the court below. Only two documents. One document is voter list of 1965 father, and one document is school certificate. My lord. The two documents.
Ms. Dharma, this is a case described by the lawyer.
I have not gone through the records yet.
No, there are materials here, but the lawyer has no idea of trial. One of the worst conducted cases. The harshness of comment against the lawyer would be insufficient. Please come to page 21. This handwritten note at paragraph 6.
Exactly, yeah. That the opposite party's father, late Virendra Chandra Sen, was a bona fide citizen of India and was a permanent resident of Blessed Lalok district, Sunitpur,
And then
earlier
come to page 26.
Assam. 26. Yes, okay. Okay.
Documents are set there. Well, it will प्रश्न बुद्धि से था remember इस आपके ऊपर परियालो इंडस्ट्रियल में देखी नया दिगंत तो बसोर सुबह असने की नाई and that cell deed is there in the record. Copy of the cell deed is available in the record. That means the petitioner would have provided the document. Can be helped.
It's not
Heard.
mentioned in the-
Hmm?
not mentioned in the.
No, because it was not exhibited. This is a harshness of comment against the lawyer would be too lenient.
Consider.
He can't do it. We are bound by our jurisdiction.
Otherwise, there's no linkage.
Hmm?
We should not find any
There's no linkage.
linkage now.
Heard. Mr. F. Hassan, learned counsel for the petitioner. And so for the respondents. Next one, by filing this petition under Article 226 of the Constitution of India, the petitioner, namely so has sailed the opinion dated 27/2/2019, passed by so in page 27, by which she was declared to be a foreigner post 25/3/1971. Next one. Pursuant to receipt of notice, the petitioner appeared before the learned tribunal and had filed a written statement. So, apart from usual denial, the petitioner had stated that she was born and brought up at village Lulukai, Lulukai, under PS Dhekajuli in the district of Sonitpur from Assam. And she had studied in Aurobindo, Aurobindo, Vidya, Vidya, Niketan, comma, Lulukai, number 2, Lulukai, comma, number 2, Pirakata, Pirakata, comma, district Sonitpur, up to class 6, and left the school on 31/12/1971. According to the admission register, comma, date of birth is 4/5/1979. And the headmaster of the said school had issued her a transfer certificate dated 9/6/2005, comma, where her name has been recorded as Shobha, Shobha, Rani Sen. And her father's name is recorded as Birendra Chandra Sen, Birendra stop Sen. Stop. She got married about 20 years back to the Bimal Biswas of village Horupadgaon, Saru, next word, Patgaon, under Tejpur PS, in the district of Sonitpur, from Assam. And since her marriage, she is residing there. So the Lat Gambura of village Lulukai has issued a residence and marriage, a certificate regarding residence and marriage. Yes, her parents had casted their vote in in 19. It cast the vote and their names appeared in the voting list of 1965 of the same village under number 76, Missamari, Misssamari, LAC. Her father died about 30 years back, and in his lifetime, he had purchased a plot of land and was paying land revenue for the sale. And her mother is presently a voter of 72 Borsola, Barchala, LAC. So accordingly, the petitioner claimed to be a Indian citizen and not a foreigner. Next para. In support of a defense, the petitioner had filed her evidence on affidavit, and while reiterating the statements made in the written statement, had exhibited the school certificate dated 9/6/2005 as Exhibit A, semicolon, PAN card as Exhibit B, a mother's photo identity card within bracket Exhibit C, and her mother's PAN card within bracket Exhibit D. And what is detail of 1965 within bracket Exhibit? So what is 1965 showing name of her father within bracket Exhibit E? Next paragraph. Not next paragraph, same paragraph. The petitioner, who had examined herself as DW1, on the tribunal's query, had stated that, had denied that query of the tribunal as to whether, query of the tribunal as to whether her family having proceeded in the foreigners tribunal, she replied in the negative. Next part, learned tribunal, appreciating the pleadings and evidence on record. Rejected the school certificate within bracket Exhibit A in light of decision of the Supreme Court of India in the case of Biradman, B-I-R-A-D, next word M-A-L, next word Singhvi, S-I-N-G-H-V-I versus Anand Purohit, comma, 1988, supplement SCC, SUPP, SCC, 604. By holding that the school certificate has no evidentiary value unless the person who made the entry or who gave the information relating to date of birth is examined. And in this case, the issuing authority had not been examined along with the admission register to prove the entries. The PAN card of the petitioner and her mother within bracket Exhibit B and Exhibit D were rejected as they were not income tax pays and they did not exhibit any income tax return. And in this regard, reliance was placed on the case of Narmada, N-A-R-M-A-D-A, Devi Gupta, versus Birendra, B-I-R-E-N-D-R-A, Kumar, K-R, full stop, Jaiswal, J-A-I-S-W-A-L, within bracket 2003, bracket was 8 SCC 475, full stop, accordingly, comma, as electoral photo identity card has been held to be not a sufficient supporting document for citizenship in the case of Babul Islam, B-A-B-U-L, Islam versus State of Assam and others, comma, WPC 3547/2016, comma, decided on 9/5/2018. Comma. It was held that the said identity card would not be a proof of citizenship. Next paragraph. Accordingly, the petitioner was held to be a foreigner post 25 to 1971. Next paragraph. The learned counsel for the petitioner had referred to the exhibited documents and had submitted that as the petitioner could exhibit the voters list of 1965, which contains the name of father Birender, B-I-R-E-N-D-E-R, Birender Sen, son of Bijoy. And the link of the petitioner to a projected father can be proved through the school certificate within bracket Exhibit B. School certificate Exhibit A. And that her PAN card contained the name, PAN card in bracket Exhibit B contains the name of her father. Petitioner could not have been held as to be a foreigner. Next paragraph. opposing the challenge, the learned standing counsel for the border and active matters has submitted that has made a submissions in support of the impugn opinion and has stated that the petitioner has failed to establish a link with the persons whose name appeared in the voters list of 1965 within bracket exhibit E. Just try. Voter detail of 1965 within the exhibit E. Full stop. The voter detail. What's the next paragraph? Consider the submissions made at the bar and also peruse the records of the learned tribunal, which was called for. Full stop. Next paragraph is on a perusal of the record, it appears that the document which was proved as exhibit E is the NRC voter detail which the petitioner claims to be the voter detail of the year 1965. Full stop. Should be it is well settled that the NRC voter detail is not a proof of citizenship. So in this case, the copy of exhibit E, available on in the record discloses that it has an image ID semicolon, colon 19206699, and it is further stated that the same is generated by DLDD version 2.5, which is sufficient to indicate that this is a computer printout from the voter detail available in the website of the state coordinator of national registration of citizens. So therefore, being a computer generated printout, the provision of section 65, capital B of the Evidence Act, 1872 would be applicable, and the computer generated printout has to be proved in a manner prescribed thereunder, which was not done. Therefore, SVT does not have any evidentiary value. Full stop. Next one, the learned tribunal had rightly rejected the evidentiary value of the school certificate within bracket exhibit A, as the author of the certificate did not come and depose along with the school admission register, which is the primary evidence, and the transfer certificate would only be secondary evidence. Full stop. Next paragraph. The PAN card within bracket exhibit B and exhibit D, as well as the electoral photo identity card of the petitioner's mother within bracket exhibit C, are all post 25/3/1971 document. And in this case, the petitioner has not disclosed anything which would indicate that she's an income tax, she or her mother is an income tax payee. Stop. Therefore, comma, the entries in the PAN card would be as per the disclosure made by the petitioner. Stop. This court in the case of what is the decision on that PAN card? What is the decision on PAN card?
Holding a PAN card does not entitle citizenship lordship.
Yes.
Yes, I'll just give it to the court master.
Okay. Okay, it is Rabia Khatun. This court in the case of Mustamat, MUSST, Rabia RABIYA Khatun versus Union of India and others, WPC 4986 of 2016. Decided on, this you have to find out, huh? Decided on so and held that PAN card is not a trustworthy document for the proof of citizenship. More so when the proceeding was not an income tax paying. And it was further held that the PAN card was not proved by calling the income tax officials regarding the application for the PAN card. To stop. It was further held that if the PAN card contains the date of birth, comma, the petitioner should have mentioned it in her written statement. Full stop. In the present case in hand, also, comma, the petitioner had not disclosed the date of her birth. It is there. Don't say that. Ask later. Okay, you said that in this case, as per the entries contained in the school certificate within bracket exhibit A, comma, the date of birth of the petitioner was recorded as 4/5/1979, whereas in the PAN card within bracket exhibit B, the date of birth of the petitioner is recorded as 4/9/1979. So thus, comma, there appears to be a variation in the date of birth recorded of the date of birth of the petitioner. Next paragraph. Be that as it may, comma, the petitioner had not exhibited the voters list of 1965, wherein she claims that the name of her father is recorded. Let's stop. The existence of the father and the father or her mother is not disclosed. In any document produced by the petitioner. Full stop. The petitioner has not disclosed the date of death of her father, the continuous stay of the parents of the petitioner after 1965, and they continued their name appearing in any voter list together after 1965. So the petitioner has also not needed regarding grandparents, comma, siblings of her father or about her own siblings. Next paragraph. Accordingly, comma, the court is of the considered opinion that there is no infirmity in the opinion rendered, or impure opinion rendered by the learned tribunal, as the exhibited documents do not link the petitioner to her projected parents. Next paragraph. Resultantly, comma, this writ petition, the challenge made in this writ petition fails and the writ petition is dismissed. Next paragraph. The consequences of the opinion would follow. Next paragraph. The registry shall send back the records of the learned tribunal along with a copy of the order to be made a part of record by the said learned tribunal.
Honorable Prayer Lordship, regarding the item number 7, we could not trace out the file, Lordship. So my lord, one is coming to given.
No, please wait, we'll have to.
The file, Lordship may take it as a ex parte order and petition never appeared. So maybe go on.
Item 7.
7.
So they will take it on 3rd. All these matters are fixed on 3rd.
I think 3rd Lordship is fixed up.
Yes.
It may be fixed on 3rd Lordship.
Okay.
In the meanwhile, even we need a copy. We also, our petition is also not. Our writ petition copy is also missing, Lordship. So we'll also need a copy.
Okay.
Item 7 given.
Seven. Watch. It was in the last number. The bail granted to the petitioner by order dated item 9 or 7. You see both sides are represented. In this case, the opinion of the tribunal was passed ex parte against the petitioner. Most of all, few of such matters are stated to be listed on 3/8/2026. Next time, list this matter on 3/8/2026. In the meantime, you give her a copy, you get your file.
Lordship will have to take it from the court. Even Mr. Biswas does not have a copy. He asked me also.
But there can't be a possible order of
Lordship,
making photocopies of the record because that is not
only
permissible.
petition, Lordship.
Only petitioner along with the annexure, my
No,
lord.
but there can't be a judicial order because, you
But
know,
can, Lordship allows, can we take a photo here and print it out, Lordship?
that is not permissible. But
Or
there may
Lordship
be-
will direct the court master to give it to us, Lordship.
To ask.
No, because you see, that creates a wrong precedent. The problem is not without, for that, because we have a good rules for the purpose of inspection. We have a note there not to make copies.
Gone through it. I have no problem now to submit.
No, but state can get a certified copy. It doesn't, would not matter much to the state. But once we give it to one, then we have to
Yes, Lordship, I understand.
do that to all. We can't have two standards following here. That's the difficulty.
Will you apply for secretary?
Yes, okay.
For motion, item 4.
For that matter, Lordship, where no documents were submitted before the tribunal. The matter was first listed on 18/12/2019. Notice was not issued, it was, records were called and entry was granted. After that 3 dates, petitioner has not appeared and last 2 dates were adjournment, Lordship. And not a single document was exhibited.
No.
That is there in the.
That is there in page 33.
Yes, Lordship.
Did not exhibit a single document. We noted that.
Because she's on interim, this matter is getting adjourned again and again, Lordship. Lordship may vacate the interim and let them do whatever they feel like doing.
Lordship, I humbly submit that it may be given a short date on Friday or Monday.
Not a single document, Lordship, I think.
Okay.
Can we draw Lordship's attention to the opinion, Lordship? Page 33. Second last paragraph, upon perusal of the case record, it appears that though the proceedee mentioned about her father in the written statement and evidence on affidavit, but she has not produced and exhibited a single document by which she could make out the linkage with her father. Last chance, Lordship.
Here, made by learned counsel for the petitioner, the matters and adjourned for the last time. There's a lot of adjournments have already been granted. Next, just make clear that on the next date of listing, the matter would be heard on the basis of materials available on record. No prayer for adjournment on behalf of the petitioner would be considered. Next, list on
31st Lordship.
21/7/2026.
Deeply obliged, your lordship.
Fine. The second time is with-
Item 5.
Same with this also, Lordship. Interim was granted on 11/5/20. After that, again one Passover, and just 2 days back, there was a adjournment, Lordship.
Yes,
May I please, lordship, kindly this matter be adjourned for the day. My senior is not in the town. It's outside.
no, adjournment is not a remedy. You have to do it someday.
Lordship, I don't have brief with me. Kindly give us the last. Six to, yeah. It's so copy.
This one, 5/8/2026. No adjournment on the next date, 5/8,
Lordship, last chance.
no adjournment.
No,
Item 6 for motion.
So in this case, my lord, petitioner's brother was implicated. He was declared as an Indian citizen, my lord, by the same tribunal. That is, your lordship will find the judgment at page 13, my lord.
14,
13.
13. Yes,
Well, is the brother of the petitioner. He was declared as an Indian citizen, and the same tribunal, my lord, declared the petitioner as foreigners. But in fact, my lord, the petitioner's father migrated from East Pakistan in the year 1964, my lord. There was a communal riot, my lord, and they were sheltered as a refugee camp. Thereafter, my lord,
yes.
So, my lord, I think, my lord, if your lordship may kindly call for this record, it will help us. Page 13. And
Which page is that refugee certificate? Which page is that refugee certificate?
certificate. The record has come, my lord. One more time, next this will be happening. Next, page 24. Kushinra Namosujo. New migration camp, 1964, Silkoraj.
Page number?
No, yeah, 1964, there was a communal riot in East Pakistan.
Okay. But apparently the document relied on by your brother and you do not appear to be same. We'll tell you why. Please come to page 14. Para 5. His name appeared in the migration certificate issued in the year 1965. In your case, there is no migration certificate which has been exhibited.
But this registration certificate was exhibited.
No, this is not a registration certificate. What you are showing us is stay in the refugee camp, which is valid for a particular period. And your copy shows that you left the camp on 5/2/1965. Your father left the camp on 5/2/65. So if it is a migration certificate, then you get the benefit of petitioner's father. Petitioner's father. We'll call for the record. But Mr. Das Gupta, Learned Senior Counsel, assisted by Ms. B. Das, Learned Counsel for the petitioner. And so for the response. Next para. The Learned Senior Counsel for the petitioner has referred to Annexure B of the writ petition and has submitted that the brother of the petitioner was declared to be not a foreigner by opinion dated 11/6/2018, passed by the learned member, Foreigners Tribunal number 2nd, Dhemaji, Silapathar. Next, the court is inclined to call for the records of FT, page 13, FT2, case number so. Disposed of by opinion dated 11/6/2018, passed by the learned member, Foreigners Tribunal 2nd, page 13. Next, requisition for the same may be sent through email to the following email address of the learned tribunal. Next, list on so awaiting receipt of the records of the other case. Next one. Before that, you say that the in terms of the earlier order of the court, the records of the instant cases received from the learned tribunal. Next para. List on so awaiting receipt of the records of that page 13.
Rule may be issued, no? Rule can be issued, no?
Lordship,
No, not really. It goes for
admission hearing.
So it may be listed for admission hearing.
Lordship, I pray for a copy of the petition, Lordship.
You don't have the copy?
We don't have it, sir.
All right. I'm giving it.
Awesome. See that. Next para. In your declaration, issue notice returnable on so you date after 2 weeks.
I give her.
Letter extra copy of the petition we provided the learners final for the FT and borrow matters within 2 days.
I'm giving it.
Okay.
Index numbering for
Hold on.
Okay, so you say that extra copy is served on the learners final. Next para, list on so awaiting receipt of the records of so page 30. Okay.
Admission column.
We come to the admission column. This is the admission column also.
Item 8,
Lordship. Item 8, Lordship, we would like a copy of the petition. And this is listed first time after, it was listed in 2020. So notice has not been issued in this. It was only LCR and interim Lordship.
Yes.
Lordship, notice may be issued, Lordship. It was not issued.
In this case, the material required for issuance of notice is not there. Page 50 is opening.
Lordship,
About the writ petition,
no, Lordship, I don't have it. That's the reason I was.
okay,
Thank
you see this, we are sending it to you. We are flagging two documents. Here, what had happened was in during the proceedings of the tribunal, the petitioner exhibited only 3 documents. We did not create a link. So thereafter you will find the first flag is that a review petition was filed. The review petition, there was a delay of 7 days. So condemnation application. So the third flag is that order in the condemnation application where the lawyer was absent and the matter was dismissed. Not for non-procedural because there is no provision for continuing the delay on that ground. But in the second flag, you will find that now the petitioner has produced 6 or 7 voters lists from voter detail of 1966, voter list of 1966, 70, 85, 97. So those are now produced.
If this is
So this is a case of
19, Lordship.
and this, yes, the third flag you will find that the order was passed on 28/11 and this writ petition was filed, I think, 10 or 11th of December.
December.
So within 12 days, the petitioner came before this court.
Everything was running time, but somewhere it got missed, Lordship. And then COVID came, the matters were not listed. I said, Lordship, even though the writ petition was filed on time, but the delay was there because of COVID was there in between.
No, not COVID, because that time notice was issued in 2019 only.
Yes, 19 only, that's what I said.
So after 20, this is now it has come.
And it has been listed only now after that. Since Lordship, review was not considered, Lordship
That's what we were thinking.
can consider.
But look at this document first. First,
I have seen the,
so
first,
the second fact, just see, be satisfied.
the application which was filed within 7 days. Review application.
Beyond 7 days,
Yes.
37 days,
It was just delay of 5 days, right?
7 days.
Here it is 5 days.
Okay. Now in the order, it says
Yeah,
7
there
days,
is a delay of, but in the prayer it says
5
that
days.
5 days.
Whatever the order of the tribunal is 7 days.
7
We
days.
accept that.
Yes, sir.
We have to consider on merit.
Yes, sir.
Now we'll ask you, you want an adjournment? No. Third miss,
S for bill,
S.
for bill.
Parveen, learned counsel appearing on behalf of Mr. R. Ali, learned counsel for the petitioner. Also heard so for the respondents. Next, by filing this writ petition under Article 226 of the Constitution of India, the petitioner, namely so and so, has assailed the opinion dated 23/5/2019, page 50, passed by so and so in FT case number so and so, by which the petitioner was declared to be a foreigner post 25/3/1971 stream. Next, it may be stated that in course of the proceedings of said FT case number 143 of 2017, the petitioner had exhibited only 3 documents, being copy of NRC for the year 1951 within bracket exhibit 1, copy of voter list of 1989 within bracket exhibit 2, disclosing don't write the disclosure 951, and copy of voter list of 1997 within bracket exhibit 3. Post of the learned tribunal held the NRC of 1951, which was prepared under the Census Act of 1958 to be inadmissible in evidence, and accordingly did not find a link of the petitioner with the projected parents on the basis of exhibit 2 and exhibit 3. And accordingly, the petitioner was declared to be a foreigner post 25/3/1971. Next, the the petitioner had approached said learned tribunal by filing review application under Order 3, capital A within bracket 2 of the foreigners within bracket tribunals, bracket close order, 1964, for review of the opinion dated 23/5/2019. The said application was filed on 29/6/2019. And accordingly, separate application was filed under Section 5 of the Limitation Act for condonation of delay of 7 days beyond the period of limitation in filing the corrected appeal, corrected review. The record of the tribunal discloses that when the matter was listed on 28/11/2019, the petitioner was absent without steps, and accordingly, the learned tribunal, with a view that the review petition can only be entertained within 30 days of the date of the order, as per Order 3, capital A within bracket 2 of the foreigners within bracket tribunals, bracket close order, 1964, held that the application filed beyond the period of limitation is rejected. The application was filed beyond the period of limitation and therefore it was rejected. Mr. Agreed by the order dated 28/11/2019, as well as the impugned opinion passed on 23/5/2019. The petitioner has filed this writ petition on 11/12/2019. Next paragraph. It is projected in this writ petition that the petitioner was wrongly carried by his learned counsel in course of the proceedings of the learned tribunal. Next paragraph, the learned standing counsel for the border and FT matters has opposed the prayer made in this writ petition on the ground that review which is not filed within the period of 30 days ought not to be taken up for consideration by the learned tribunal, and accordingly it is submitted that the review was rightly held to be not maintainable. Not the review, the application for condonation of delay accompanying the review application was rightly held to be not maintainable. Full stop. Accordingly, it is submitted that the documents exhibited by the petitioner in the main proceedings do not establish the claim of the petitioner as a citizen of India. এইটো কেনেকৈ overcome কৰিব দিম? এইটো show কৰা নাছিলে। There's something we did not notice, and suddenly while flipping papers, we came to know about. We have seen this evidence. You have someone with you, or you can read the English translation. You have a copy of your writ petition? Please give it to Ms. Verma. You also come this side, look into that. In this writ petition, please come to page 49, that is the Assamese version. English is 47.
Yes, Lordship.
Here it says in the cross-examination, it is not a fact that Ismail Ali and Ismail Sarkar are not the same and one person. I do not know as to why my father's name has not been recorded in voters list from 1951 to 1989. Now here lies the problem. In Assamese also it's almost similar. 51 Sonarpura, 1989, Sonday, Jo, Deotar Nam. Voter Talikat Nam Nai Manayanu. Therefore, it's okay, you can read the English version, it's correct. You can read it, page 47. I don't know why your father's name is not recorded in the voters list of 1951 to 1989. But that means this page 47 discloses that this examination and cross-examination took place on 13 to 19. Therefore, if the petitioner had a document, they would have produced it then. Now it would be that in order to overcome the lacuna, this
Review was filed.
review has been filed. So that requires a determination.
Fix it up for hearing, Lordship.
You have to address it. This has to be heard. We missed out the cross-examination. Check out that, but check out that, you just say both sides are represented. Pursuant to order passed earlier, the records of the tribunal is received, which requires determination. Next para, list issue notice returnable on so and so. List in the admission column on your date after 15th of August.
Copy of a writ petition.
Okay, just say issue this, then say that extra copy of the writ petition be served on the Learned Standing for the border and entry matters within 2 days. list on so the admission column.
No opposition.
Oh, we'll take a short break and come back.
Motion item 9.
May please allow. But the impugn order number page 85. Here, my lord, the voter list of 1965 and 70. In 70, my lord, my name is appeared along with my parents, my lord. And voter list of 1965 and 70 has been, my lord, not considered on the because, my lord, it was not proved by comparing with the primary evidence. Original document. Findings, my lord, page 88, last paragraph.
have Lordship.
See, can you please come to the opinion?
At page 86.
It starts from 85,
Yes,
then turn to page 88. This is the last paragraph. Here, this is how it is rejected.
UCD submitted 65. I have gone through. Yeah. This is 17. 17. Yes, Lordship. Yeah. In the WS, he does not mention about his brother at all. The petition, Lordship.
His name, para 6, page 25. Name appeared in the voter list of 1970. Now, so far as the nationality travel is concerned, the exhibit 1 and 2 was discarded. What is of 66 and 70 as it was not proved by comparing the original document. That's the reason assigned. But in the opinion, please come to page 89 again. Voter list of 1989 has been appreciated. Some arithmetic has also been done. So if you reject voter list,
60,007.
you will have to have the same parameters. Why do you accept and appreciate one voter list when you are not doing so for the others? 89 was also not called for. The original records were not there. That is one. But Mr. Adi, against you, there is a issue. Even if we accept everything, yet you claim that your parents died before 1989. Page 25. Para 7. And this is your specific statement that your parents expired before the year 1989. Therefore, their name don't have appeared in the 1989 voter list. Your mother's name is your brother produced that 89 voter list. For that, you'll come to page 90. GW3 stated that his name along with his mother appeared in the voter list of 1989. But you say died before 89, so therefore there is a mismatch of the evidence, which makes your parents doubtful. Even if we accept this exhibit A and B or 1 and 2, this 66 and 70, yet you get trapped here. There is one more reason to discard everything. Please come to page 78, Mr. Adi.
No, 70.
78. page 78, paragraph 24, you displace the name of your brothers and sisters, brothers so-and-so, and one Samsul Haq. After Jainal Abdin, it is Samsul Haq, right? Samsul Haq, there's an opinion, page 50, declaring him to be a foreigner.
No, not for another. Is 50, madam.
Oh, not a foreigner.
Okay.
But
And-
Ms. Verma,
Yes, Lord.
And 70
there's a judgment of this court in 2025 where this bench had stated that wherever there are opinion rendered without any discussion and without any appreciation of documents, for those cases, you have to you have to challenge those opinions. You have not done so.
Mr. Pine would be able to tell us. But Lordship, in this case, Lordship, even in the additional affidavit, additional written statement, he has not mentioned about his brother who is deposed as DW2. And we have a citation to that effect that if pleadings, there cannot be a variance between the pleadings, Lordship, and proof not permissible, Lordship. I can refer to that, Lordship. You will just read a small paragraph.
First is that you have to examine and tell us what is
A sudden appearance of a person whose name has not been mentioned in the WS or,
no, that's okay, but you have to also address us
yes,
on
Lordship.
this exhibit, this 66 and 1970.
Yes, Lordship. Lordship, the 66 and 70, 66 seems to be a handwritten one, and it is not written certified to be a true copy. I have just gone through it, Lordship.
Okay, then shall wait for some time. Let him complete his submissions. Pick up your.
Okay.
In the 66, oh, is it?
66, 65, is 19, 29. 29, 38 document. Probably that's what I mean. Activate cookie will be a knockdown karaoke.
Doesn't looks like a knuckle. Discuss this matter on Friday, Lordship, then we'll address on the 65 certificate, voters list and 70, Lordship. 65, I have my doubts, Lordship, whether it's a certified copy or not. There is no folio number, no date, nothing, Lordship, on, so in my copy, I don't have anything of that sort, Lordship. Page 11, he लिखा से
811, 93,
Huh?
93. Serial number 1599. Record of sound. 1599. For proceeding. 811.
See, both sides are represented. Pursuant to order passed earlier, the record was travel is received, someone requires examination. Explanation notice returnable on date after 15th August, returnable on so-and-so. List in the admission column on so-and-so.
Lovely.
Item 11.
May I please? Lord, the import order that you Lordship will find at page 88. Page 89 is the Lord decision and reason thereof, my Lord.
Yes.
Lord, since Lord, TCR has been Lord received, my Lord. So may I pray, Lord, let it be posted for admission hearing in the Lord next month, my Lord, for final disposal, my Lord.
ठीक है sir.
Norman, you can look into it. You see, we have to back at two places. One is the one is a filicity by virtue of which the documents were filed. Now, look at this document. All original were taken back on 14, 10/19. So now, this next page is are the documents. They are photocopies and they were not signed by the tribunal. Therefore, none of your documents were exhibited. And therefore, this is something you can't do anything about. Then the other fact is that there was an earlier opinion of 16/11/2016. Please come to page 42 of your writ petition.
42.
Yes, about third or fourth paragraph from below. Though OP has submitted his written statement and only photocopy of documents, those photocopy of documents cannot be treated as genuine. So this was an opinion. Perhaps against this, you filed a writ petition, page 43.
Yes.
43, you got an order to go and re-examine this DW3. Correct?
Correct.
But the records of the tribunal which is there, it discloses that DW3 did not come up. And therefore his evidence was DW2 and 3. They did not turn up and therefore their evidence was closed.
Yes.
And so far as you are there, please come to page 49 and turn over to page 51, 13/11/2019. OP is present, OP is submitted. Our documents may be kept in the record for the argument fixed on so and so. But there's nothing on record because earlier you had taken back the records on 14/10/19. With the DW2 and 3 closed and the original documents not being there, which is reiterated in the opinion. In the present opinion also you will find the same thing. Page 89.
89.
Fourth last paragraph, last two lines, that apart documents submitted by DW2, exhibit A2, so exhibit so I can read, are found to be photocopies and therefore not admissible in the eye of law. There is nothing much you can possibly argue.
I have a DW2 is the nephew of the petitioner. Nephew. Written statement.
You will find at page 37, there is a written statement, and at page 39, there is a written objection. Now, we don't know how these two could have been filed, but nonetheless, your brother is not there in this, both the written statement and written objection at page 39. Therefore, sudden appearance of nephew to prove your documents. That is something which is out of our concept because of Order 1823A CPC.
That is how the Muller trial was conducted before the tribunal.
I am not a lawyer,
That is true, Muller.
so unless we can exit this prefix, we are bound by it. You see, in a light of note, there's a married in this situation. Chartered accountant has to complete a number of hours of workshops. And those are pre-notified that the particular program would be getting you that accreditation marks. And if you get a total, you have to get a total of minimum number of marks to have an accreditation for your license to be renewed for the next year. So therefore, they have to, a chartered accountant will compulsorily have to attend workshops, seminars, gain points, and then renew their license for the next year. And we don't call them a learned chartered accountant. For this profession, incidentally, once you get a degree, get this tag of learned. So therefore, we won't bear anything against a lawyer. But there is nothing then. There's absolutely no way to hear anything. Not even in this written statement, in your additional written statement. There's a big gap. In the written statement, you have a gap from 1966 to 1997. So there was 31 years gap, which was reduced at page 39 from 66 to 89. In between, there is nothing. And whatever else remained will again non-suit you because of page 46. Come to page 46, this is a part of the High Court order.
Yes.
Second paragraph, we have heard the learned counsel for the parties and also perused the records. Apparently, the petitioners filed written statement and evidence on affidavit. We are of the opinion that for one board of stating granted the petitioner contest the police reference on merit. In this way, the matter we set aside the opinion date so with the direction the petitioner to appear on the date who shall adduce evidence. He shall adduce evidence. So this evidence could not have been through DW2 and DW3.
Yes.
You appeared and did not give evidence. So far as the additional documents are concerned. Who is Sahab Ali? Who is Sahab Ali?
Shahab Ali is the Malad nephew Malad,
Oh, the DW2.
DW2.
Yes, Mr. Mandal.
Yes. Malad, since Malad this year has received Malad, so Malad, may I pray Malad, let it be posted for admission hearing in the
But
next
there's
week.
nothing here. In fact, if you had an arguable point, we would have definitely considered that. So this is a position which can't be rectified.
Right.
Okay, both sides are represented. The pursuant to orders passed earlier, the records of the tribunal is received, comma, which requires examination. Next para. On the prayer made by Mr. M1 by the learned counsel for the petitioner, comma, issue notice returnable on. Give a date after 15, returnable on. Without requiring any steps to be taken. List in the admission column on. Mr. Pang, just make a note because we may forget. In this case, there was a ex parte opinion, there was a order of remand. On remand, the direction was that the the petitioner would examine, would produce evidence. But in this case, the petitioner did not come as witness. He appeared only for his cross-examination. DW 2 and 3 came. 3 ultimately did not turn up. 2 came, but the documents which were filed were only photocopies. So therefore, those were rejected. And there's a sequence of the applications and all. The appearance was made by the petitioner. The original, the records show that at page 0069 of the TCR, the original documents were taken back on 14/10/2019. Therefore, it's not a case where the documents were available and then the tribunal forgot to put the signature because the exhibited documents contained the mark but was not signed by the tribunal. So there's an inherent defect in the manner in which the proceeding was taken up.
Item 13 for motion. Item 13.
In this case, we are finding a situation here. The opinion is against Umesh Malakar. This Umesh Malakar, as per page 19 of the rate petition, he joined service in the NF Railway in 4/12/1979, and he is superannuated. And as per the statement made in the rate petition, he retired on 4/12/1979. Oh, sorry, 30/10/2005. And he died on 7/9/2015. This, as per the tribunal, he had appeared on 2/8/89. This Malagar, this Umesh Malagar. 2/8/89, his thumb impression is there. He took the documents and thereafter did not appear. And the ex parte opinion was passed in 1990. Now, these family members, they have come to challenge this opinion. We were not aware of this. They are now producing documents to show that '79 he was in service. Presence before 71 is not available.
In this case, my lord, I'm sorry to say, actually, I missed my file. I missed my file somewhere, my lord, misplaced somewhere my file. But Mr. PCD is also, my lord, on leave. He has filed a leave of absence. Mr. PCD also filed a leave of absence in the my cost plan.
Oh, acha, is it? Okay. None appears on call for the petitioner. However, the name of the learned counsel for the petitioner appears in the leave column of the cause list. Next para, all the respondents are represented. Next para, pursuant to order passed earlier, the records of the tribunal is received with comma which requires examination. Next para, issue notice returnable on so and so. Is the matter in the admission column on so and so.
Item 14.
Lord. Yes, my lord, the issue was called for and the petitioner in interim, my lord. But as per the official, it is seen that, my lord, this is not received, my lord.
Yes, you notice that. Okay. Both sides are represented. As per office note dated 24/6/2026, the traveler's record is not received. As per accordingly, the registry shall send a reminder for the records through the following email address of the learned tribunal. Next para, list on so and so awaiting receipt of the records.
Item 15.
Maybe. In this case, my lord, the notice was issued, notice was not issued, my lord. The LCR, TCR call for and the interim was granted, my lord. Notice was not issued. My lord. Impon opinion of 61, my lord. In this case, I have gone to the, my lord, judgment they only count the discrepancy of the age in the voter list, my lord. So at this stage, your lordship, I humble mention, my lord, let the notice may be issued and let the matter keep for it.
In this case, there's the point which you are raising,
Yes, my lord, then my lord,
You'll-
come to page
you'll kindly come to the,
19, my lord.
no, come to the written statement.
Opinion, my lord, 19. Written statement, my lord, page.
It's
Annex
on page 43.
43, my lord, annex 16, my lord.
Now,
And
the-
he was born 1977.
no, not, that is not relevant, but you'll have to come to page 45 onwards.
45, my lord, regarding
Um,
shifting, my lord.
No,
My lord,
not on that. You see, you are referring to the discrepancy of names. In the,
age, my lord.
in terms of age.
Age,
So
my lord.
in terms of your this Sirajul Haq and other cases,
Yes, my lord.
you see,
Like, yeah,
they have not been able to show that
basically,
the,
my lord, in judgment, my lord, when opinion, my lord, basically, my lord, the age discrepancy, my lord, clearly
no,
mentioned.
we understand, but that foundational facts is not there in your written statement. Foundational facts would be that the voters of the, in all the voters list must be similar.
My
Then
lord,
you get that benefit.
my lord, the case is that, my lord, at the time when, my lord, submission by the voter list, my lord, all the voter list, my lord, we have included the date of birth and the presence at that time, the age, my lord. And in the conclusion, it is seen that, my lord, the age at the time when the voter list was prepared and the date birth. And on on this voter list, my lord, it is seen that my lord, some discrepancy, my lord, is, and regarding the, my lord, the name, my lord, only, my lord, the 97, my lord, the petitioner name was, my lord, normally it was subsequently it was corrected, my lord. 97 voter list, and all the voter list petitioner name is recorded with his mother's, my lord, also. And 1970, my lord, his mother name reflected, and 1966 onward, and petitioner named Asar, my lord. And thereafter it was, my lord, rectified, my lord. 97 onward, my lord, rectified, my lord. Asabuddin, petitioner name, 2005. With his mother name also, my lord, reflect here, my lord. Next, my lord, 2000, it is executed document, my lord, 2011, my lord. Asabuddin, petitioner Alsuma Khatun, petitioner mother, my lord. Next, my lord, 2016. Only, my lord, only 97 minor decision Asar and Asab. Here, my lord, ASR B R. And another petitioner fathers recorded in 1965, 71 onward. And his father was expired 1982, 83. Thereafter, the petitioner name recorded with his mother's, my lord. Also, my lord, last 2016 and last exhibit, my lord, 2019 voter list. All the voter list included the petitioners with his mother and other family members, my lord. I rely mainly, my lord, his mother name recorded, my lord, 2011 and 2005 and 97, all the voter list, man. And the learned tribunal, my lord, the calculation, on the basis of the calculation, there is a discrepancy, my lord. And regarding, my lord, on shifting, my lord, my grandfather, that was also mentioned in the related mention. It was mentioned. Regarding shifting part also. That discrepancies, what my lord we have mentioned in our statement, my lord. We-
Okay. Both sides are represented. Pursuant to order passed earlier, the records of the family is received, for which requires examination. Next, accordingly, issue notice, returnable on so and so. Next, list in the admission column on so and so.
Hello, lord.
You see, the problem is that in your written statement, you don't give the, disclose the names, disclose the names and the discrepancy. And therefore, at the evidence stage, you are adding up names. This is beyond reading. Therefore, not matching.
My lord, that, still, my lord, the voter list, my lord, they only just mention the voter list once also.
That's the problem.
This is the one.
That is the problem. Okay, but in here,
Hello, hello, my lord.
Item 17.
Maybe. But in this case also, my lord, PCR has been, my lord, received. And, my lord, lordship will find, my lord, the impugned opinion at page, my lord, 88.
88 years.
Basically, my lord, on, my lord, age discrepancies as reflected, my lord, from, my lord, page 92. First paragraph itself, my lord.
The examination of your Gauhati did the needful.
Yes, that is. Asiran, my lord, she is, my lord, not a stepmother of the petitioner. No? Paragraph, my lord, third paragraph is 92. My lord, she is, my lord, a stepmother and own mother is Tarabanu.
Your written statement and your stand is found to be amusing. You see, you have structured your response in a way that as per the date of birth, as per the family horoscope is so and so. A family does not have a horoscope, and at least it's not there to my knowledge. Modern times things may change, but family does not have a horoscope. Horoscope always is dependent on the on a person.
And my information, my lord, as on date, my lord, she is in, my lord, bedridden. She is about 80 years, as I have been intimated, my lord.
one extra statement in that catches our eye. Correct. So this is something which is impermissible. One extra statement in the written statement comes to notice. You never expected us to know about it. When I don't read the law, I read this. Okay. Same order. Mr. M.U. Mandal, based on so-and-so. In the admission column on so-and-so, same order.
Good law, please.
If you're not satisfied, the evidence not found sufficient.
Yes. But second week of August, my lord.
You'll give a date. Second September.
Obliged, lords.
Item 18.
The aim of the respondent has filed the affidavit, bringing on record the charge sheet. Though it was earlier submitted that the charge sheet was filed on 36/25, ultimately it was filed on 28/3/2026. On 1/4/2026, there is an order, which reflects that the charge sheet is filed on 36/25. And page 216, the officer is charged, forwarded it. Yes, madam. Page 216, can you see, the officer is charged, forwarded the CS, already on 28/3/2026, (36/25) is the date, when the IO has submitted a charge sheet before this officer is charged.
Yes, so
Now, can you see my allegation, is page 138, 134, the FIR document. It is,
just a moment. No?
Yes, ma'am. The FI is set for 137 minutes. I have supplied minute, cotton yarn minute to the 137 minutes. The FI is set for. मतलब after executing the Factora case after executing an agreement with the Assam Marketing Board I have supplied cotton yarn to the Weber's Now what has happened I employed one employee whose name is Toka Sagarala. Now he is no more during that period on 6/5/2020 two checks has been issued to me thereafter 4 checks has been received by that Toka Sagarala and his son that too with the collusion with the official of the Assam Marketing Board I made them also an accused the officials In the charge sheet there is no mention that who received the checks As per the agreement, the petitioner has to receive the checks or bill from the board Almost 1 crore 73 lakhs has been misappropriated by this accused person in collusion with the salesman.
Number one,
Yes, ma'am.
when when a charge sheet is submitted before the magistrate,
Yes, ma'am.
it would be within his competence to accept it or not to accept it,
Yes, ma'am.
or to,
Yes, ma'am.
even magistrate can direct
Yes, ma'am.
the investigation to take place.
Yes. Obviously.
Now, you have to tell us what is the scope of the examination by the High Court. Should it be examined so intrinsically that we fish out the nature of evidence collected
Yes,
and
ma'am.
then arrive at a finding?
Yes.
Because we think it is not.
Yes.
You have made a statement that in the charge sheet, there is no statement as to who took the checks.
Yes, ma'am.
Correct. Please, the charge sheet is page 213,
Yes, ma'am.
comes to page 214. About 10, 12 lines from above.
Yes, ma'am.
After 173.11.010, it says, after received 4 checks, Prakash Agarwal and his son Ishan Agarwal, by creating fake identity in the name of style of so and so,
Yes, ma'am.
opened a separate bank account.
Yes.
So therefore, the fact that the checks were collected by them is there in the charge
No,
sheet.
no, why, it was given, on the last page, he said the case, the one of the statement of the cashier of the board, the person says, the Prakash Agarwal, has put his signature of my name,
So whatever be,
Yes, ma'am.
but
But here,
what is the purpose of an SIT here?
I have the alternative pair,
The
for the de novo investigation also, because see,
do you know, so you file a, you see, against, even against the charge sheet, the manner, you can still raise an objection.
but can you see for a moment, last time of the pay gap,
You can always
Yes,
examine
sir. As a
the CJM.
provision of 153, I know, even if, I'm relying the Babul Tamang case, where the Supreme Court says, even if it is using file,
The issue is whether the High Court, while exercising jurisdiction under Article 226, could examine the charge sheet vis-a-vis the evidence collected and make any observation. We
Okay,
don't
let's
think
see,
that is
the-
an appropriate way. Whether it will lead to conviction, this is something we can't examine right
but
now.
the investigation is conducted in such a way, he will not get any justice, even if the search could not be frame,
You see, you can also charge after evidence is taken. Then earlier,
But
319, you can,
that I know, but
you can call, then you can.
the cashier says, he put the main accused, put his signature on behalf of me, my signature he has put it,
So that will be the part of evidence.
Yes, madam. That's why, the Facet does not show anything, whether they have investigated the officials also,
No, they have taken note of the check
No,
when
madam.
collected.
But there is no mention of, page 148, There is just Caesar, The can you see 148 for a moment, my repetition, Below. मतलब पे हाँ, in बाबुल तमांग केस में पेज पैरा 31 में Yes, ma'am. Sorry, ma'am. Huh? Sorry, ma'am.
You see, here, when you are referring to this Bharti Tamang case, the
Yes, ma'am.
facts of this Bharti Tamang
Yes, ma'am.
is that there was a murder,
Yes, madam.
and it was a politically instigated murder.
Yes, ma'am.
And the accused persons who were charged of, who were accused of being of
ma'am.
the murder
Yes.
were all members of a particular political party who was in power.
Ah.
And therefore, it says that the High Court will apply the mind and it will
ma'am.
transfer the case outside Darjeeling or
Madam, here, the
CBI.
Babubai case also referred, madam, when the 420, 470 was there, madam.
No, you see, reference maybe,
Yes,
maybe not one, there may be ten
Yes,
and thousands of cases referred to in their judgment. But the fact on which this order was passed is that the Supreme Court took cognizance of the deficient
Yes, ma'am.
investigation.
Yes, ma'am.
And that is given, for that, the imprimatur of the court is given on the account of the fact that the entire state
Yes, ma'am.
was supporting was preventing a free investigation, and therefore,
There are some of the persons are absconding, but the police could not arrest them also, madam. That was also the observation, madam. Here,
It is
in my
okay.
case also, madam, the Madhya Das, madam, he applied for a bail, madam. The interim was granted, madam. After we filed a, madam, IA, madam. Where, madam, the IO was asked to whether, madam, his custody integration is required or not, madam. The IO stated, madam, his custody integration is not required, madam. Now they have said that they could not arrest the absconding person, madam.
you see, those are the decisions taken at the relevant point of time. That particular observation is not under challenge.
Yes, ma'am.
The challenge here is with regard to the constitution of an SIT for a fresh investigation.
Yes, ma'am.
Now,
Now,
please,
without following with
in
the
this,
officials, madam.
in this judgment, which paragraph you are relying?
Madam, this guy. Para 33, madam, 33 onwards, madam. This Zahia Habibullah case has been referred, madam. So, बताएं बोलो. So, 1315 SSC, 570. And so far, madam, the Sasid is concerned, madam, that is reflected in para 36, madam. What? Rapid case was. Yes.
Okay. Absolutely, not 13%.
What is your submission, Mr. Bottom?
Yes, ma'am. Now, for a moment, kindly see the page 200, ma'am.
200,
Yes, ma'am.
200.
Yes, ma'am. Sorry, but, yes, ma'am.
Mr. Bottom, let us tell you first before you begin.
Yes, ma'am.
You see,
I know I have some limitation, ma'am.
no, it's
Yes.
not a question of limitation. We are telling you our parameters. Number one, you're trying to project that the IO, while he was expounding,
Yes, ma'am.
the IO did not deem it necessary to have him arrested.
Yes, ma'am.
And when you move an application for cancellation of bail,
Yes.
then the IO says that it is not required.
Yes, ma'am.
Correct. But at that point of time, you are referring to page 200.
Yes, ma'am.
There on 7.4, you are the applicant.
Yes.
You were present on that time.
Yes, ma'am.
Before the closure of the case, where the matter was closed, you did not say that you have an objection, serious objection to it because of the anything which may impede the
But the
investigation.
IO was not for cancellation of bail, madam. The IO was filed
No,
for
you
inquiry.
see, this court took it up on itself.
Yes, yes.
You did not move an application for cancellation of bail.
Yes.
It is this court which
Yes.
ultimately examined things and found out that there were irregularities in the bail application.
Yes, ma'am.
Court fees were less and therefore
initiate
instructions were issued to the registry and also instructions was asked for from the APP
Yes, ma'am.
as to whether they are interested in cancellation of bail.
Yes, ma'am. That I know, ma'am.
Correct?
Yes, ma'am.
So that is one part of it. Then when this order, this was a proceeding in the open court,
Yes, ma'am.
the APP raised an objection, did not raise an objection requiring cancellation of bail, and the matter was closed.
Yes, ma'am.
That time your objection is not recorded.
Yes, ma'am.
Now you are trying to say that please constitute an SIT because of the shoddy investigation, and he was not even taken into custody, no custody interrogation was made. Your second ground is that the investigation carried out so far has insufficient materials, which will not make out any offense for the purpose of sustaining a charge.
Yes, ma'am.
Are we required to examine that? That would mean that before the evidence, we examine the evidence and then say that this is the investigation, this is the material corrected, this will not lead to conviction and therefore SIT.
Oh.
Can we do
My
it?
submission is, my lord, without having any collusion, my lord, the officials, my lord, the board, my lord. Can that be happen, my lord? The agreement says, my lord, I have to collect the money, my lord. The 148 says, my lord, the Caesar is say, my lord. The Poker Sagar, issues some, my lord, authorized, I have issued some, my lord, authorization letter, my lord. They are false, my
You
lord.
see, please
That was
tell
not
us.
taken into consideration by the IO,
Please
my
tell
lord.
us, this is something which happens daily in our court. People file an affidavit saying or file a power attorney and say that X is the petitioner, I am authorized to take steps and therefore the affidavit in the petition is by Y. Correct? In your experience gathered so far, has the High Court anytime conducted an inquiry as to whether A appointed B as attorney and duly empowered to come before us and examine him? No. So in an office, please show us the SOP or a requirement that in an office, if somebody produces an authorization letter, they will have to doubt it. It's just like money transfer through this UPA. You transfer it and then they will ask transaction authorized, OTP, give OTP, and therefore you give an OTP and the transaction is made.
That's
Now I'll
right.
tell you something. We have dealt with them, that's why we are telling you.
Yes, ma'am.
In a given case, person took a loan. The family members were there, they took a loan. The OTP came to a person and he gave that OTP in the what you call mail which came, and a loan was granted. I forgot the sum, it was a good amount, a loan was granted. Now a person, after the loan went bad, property was sold in distress by the DRT. Then somebody comes and says that, no, I was not aware of it. And therefore, the writ petition was to undo the transaction because the person is not aware of why the OTP was sent. The stories I forgot, it's long time back, the stories I forgot. So this is what has happened. So now, can we say that this is a cyber fraud? Can we say that this is what is there? Then can we, in the writ petition, examine this transaction and then say that the evidence collected was insufficient to convict him? Is that the scope of 226?
My interesting matter that I know about. Interesting matter in the charged matter, what the IO has stated matter, the complainant, the informant, as well as the accused as a shareholder of the farm matter. It is absolutely false matter.
Give another petition. What prevents you from doing it? Is it your case that when a charge sheet is filed, which doesn't have sufficient materials, the complainant is not permitted to file a Nazi petition?
Yes, madam.
Then, you see, the reason is that can we determine in a high court and then create something by which the trial court would be bound? You see, when the trial court itself does it, it is not bound by its own orders.
Yes.
But if the High Court finds deficiency in the investigation,
Yes, ma'am.
Supreme Court says in many cases, including Habibullah, that it is in rare cases.
Exceptional
This should be
cases, ma'am.
exceptional cases, it should be done. Now, in light of that, those decisions, even I think the para 36 you are referring to,
Yes, ma'am.
Rababuddin,
Yes, ma'am.
that case also is same thing,
Yes, ma'am.
exceptional cases. Now, in that light, can we examine the evidence and then say that these materials are insufficient to arrive at a conviction? And then what happens? We're just assuming something. What happens if conviction takes place despite our observation that this is insufficient investigation? And on that basis, a conviction is made. Then what happens? Then the accused will go to the Superior Court and then say that, look, even High Court found the case insufficient evidence, and on that basis, he was convicted.
So far as the private person is concerned, madam, the investigation is paid up, madam.
Because all the authorities which are being referred to, not even in this or in this case, other cases also, a consistent stand of the Supreme Court is on those cases where the offence is heinous, not properly investigated because of the lax-sided approach of the state government.
Yes, ma'am.
Either they are politically influenced, or the police is in the
Yes, ma'am.
police is accused of being in league.
Yes, ma'am. Yeah. Please, one more judgment, madam, Babu Bhai, madam.
Hmm?
But the court has, madam, the High Court of Gujarat, madam, has monitored the investigation, madam. That is why, so for the dispute concerning the land dispute, madam.
Yes, which paragraph you are referring to?
Para 20 and 31, my lord. Then 41 and 41.
এখন দিয়া যদি ইনষ্ট্ৰাকশ্যনটো এটা ইনষ্ট্ৰাকশ্যনটো আছিলে page 21. Yes, ma'am. You start on 213 minutes. Panin na ito. Panin. Tultawin ko lang.
Bora, you have to tell us why the charge sheet is of 36/2025. The officer in charge of the police station held it till 25/3/2026. There's no explanation to it. And rather according to us, this charge sheet in the final format, page 2 and 3, is absolutely misleading. Only to that extent, you'll have to tell us. You see, because the reason is, you are backdating a charge sheet. If the officer in charge is holding it till 25/3/26, why would the charge sheet have a back date of 9 months back? Please put on your speaker, we are not hearing you.
Lordship, as per our instruction, Lordship, that we have received.
No, it could have been coming in the affidavit.
Lordship,
Your affidavit doesn't say so.
I shall again text.
What is your, please tell us, show us this, your instructions. Let us see what is there.
Earlier instruction, Lordship.
Suppose no, but this is not an instruction.
Lordship, in that aspect, regarding 25/3/2026, I shall obtain instruction.
No, do it. Otherwise, we will direct the disciplinary proceeding to be departmental action to be taken against the officer in charge. We can't do that. Prepared charge sheet is being withheld by him, and he is giving it back date. He has not informed his authorities that the charge sheet has been submitted. Here also they say that the charge sheet is of 2025. That's a false statement made before the court. On the basis of that alone, we can drop a contempt proceeding against the person. This is not appreciated because this inspector, officer in charge, he has filed an affidavit in this court where he has given the date of 36/25. We take an exception to it. And we'll put a notice as to why for misleading the court. Why a contempt should not be drawn up against him. He could have said that this charge sheet dated so and so, released on so and so. That is not saying. He has submitted charge sheet where? That is also is not saying. On which date he gave the charge sheet before the court is not stated. We are issuing notice against this person. This Charles Dole. He owes the court an explanation. Mr. S. Bhattagu, learned counsel for the petitioner, and Ms. R. Borobora, learned government advocate, appearing for the respondents. Next paragraph. By filing this writ petition under Article 226 of the Constitution of India, the petitioner, namely so and so, who is the complainant who had lodged the FIR dated 16/3/2024 before the officer in charge, Bhangagar Police Station, which was registered as Bhangagar PS case number 31/2024 under section 120 with 120 capital B. There's no bracket, right? 120 capital B. /420 /406 /468 /471 IPC, alleging inaction on part of the respondents to investigate the complaint and dissatisfied with the tardy progress of the investigation, has filed this has prayed for constituting a special investigation team for effective investigation of the said complaint. Next paragraph. The learned counsel for the petitioner has submitted that there are several deficiencies in the manner of investigation. First of all, it is submitted that during the pendency of this writ petition, although a charge sheet has been shown to have been submitted by the respondent number 4, but it does not reflect the two true and correct disclosure of the incriminating materials by the witnesses examined. Full stop. It was suffice to mention in the summary form that the allegation in the summary form, which is to the effect that the petitioner had carried out particular contract work for supply of cotton yarn under the Chief Minister's special program for the year 2015-16. And in course of time, when the payment was ready to be disbursed, the accused surreptitiously collected 4 checks from the Office of the Managing Director, Assam Government Marketing Corporation Limited, with the aid of forged and fabricated documents, and encashed the payment through a fake bank account, which was opened in the name of the firm of the petitioner and illegally encashed. Full stop. We submitted that from the affidavit in opposition filed by the respondent number 4, it is projected that charge sheet number 81/25 dated 30/6/2025 has been submitted before the Court of Learned Chief Judicial Magistrate, Kamrup Metro, Gauhati. So it is submitted that the said information is incorrect because it appears from the contents of the charge sheet that though the charge sheet is shown to be dated 30/6/2025, the said charge sheet contains the signature of the officer in charge within bracket respondent number 4 dated 28/3/2026. To stop. Accordingly, it is submitted that only after issuance of notice by this court requiring instructions to be produced, the charge sheet is shown to have been submitted. Next paragraph. The learned next paragraph. Be that as it may, be that as it may, in order to implore upon the court for passing appropriate orders for re-investigation, the learned counsel for the petitioner has relied on the following 2 cases. This is 1 and 2, I'll write, 1 and 2. Moreover, he relies on several cases which are referred to in those 2 decisions. Accordingly, it is submitted that as there was inordinate delay in making the investigation, and as the evidence collected so far are not highlighted in the charge sheet, it was a fit case for this court to take an exception to the investigation carried out so far and order the investigation. That will be okay? Next paragraph. As far as the issue of investigation is concerned, heard the learned APP in the matter, or learned government advocate in the matter. Full stop. 7, accept the issue relating to the projection made by the learned counsel for the petitioner that though the charge sheet is shown to be dated 30/6/2025, the same was withheld by the officer in charge of Hagar Police Station within bracket respond number 4 till 28/3/2026, comma. This court having noted that during the pendency of the writ petition, the charge sheet is stated to have been filed in the complaint, comma. This court is of the considered opinion that after the charge sheet having been filed, comma, it it would not be appropriate for this court to examine the materials collected and to see if whether the investigation was not carried out in the manner it should have been carried out. Stop. Even as per the ratio laid down in the cases of is 1 and 2 supra, comma, the Supreme Court of India has mandated that the monitoring of the investigation is to be done in extraordinary circumstances, notwithstanding the fact that the High Court is vested with such powers. Full stop. In this case, as the investigation is complete and charge sheet has been submitted, comma, there's no material to show that any monitoring by the court is required. Full stop. Paragraph. guided by the observations made by the Supreme Court of India in paragraph 50 of the case of Babu Bhai, that's second one, right, number 2, Supra, comma, no, strike it out, then don't say about this paragraph 50. Accordingly, comma, it is left open to the petitioner to move the concerned court to which the matter has been transferred for hearing. In which the case of the case relating to Mahagar PS case number 31 of 2024, right? 31 of 2024, where charge sheet number 81 of the 25 dated 36/2025 has been transferred or placed for disposal or trial to make an appropriate application before the said learned court to examine if any further investigation is required in the matter. First of, however, comma, the said concerned court shall take its own call in the matter without being influenced by anything contained in this order. Next paragraph. Accordingly, in respect of the prayer for reinvestigation, comma, the petitioner is delegated to approach the learned magistrate as indicated above. Next paragraph. Insofar as the issue relating to the withholding of charge sheet is concerned, comma, the court takes a very serious view of the matter because from the contents of the final form oblique report, which is annexed to the affidavit in opposition filed on 22/7/2026 by the respondent number 4, comma, it is apparent and evident that the charge sheet number 81 of 2025 is dated 36/2025. Full stop. From the last page of the said charge sheet, comma, it is clear that it is clearly evident that the same contains the signature of the officer in charge on 28/3/2026 with the name with the name of the respondent name of the concerned inspector of police clearly indicated therein, comma, which is Sri Saroj, SAROJ Dole, DOLEY, comma, who has sworn and filed the affidavit in opposition. Therefore, comma, it appears that the said charge sheet has been filed pursuant to the notice issued by the court. First of, it also appears that if the charge sheet contains the signature of the officer of the respondent number 4 on 28/3/2026, comma, this is a clear-cut case, there's a clear case that the charge sheet ought to have contained the current date on which it is actually submitted before the learned magistrate, learned chief judicial magistrate. And therefore, this appears to be an institutional lapse on part of the police authorities to have the charge sheet numbered as 81/25 dated 30/6/2025, though the same has not been submitted before the concerned court. At the earliest possible opportunity with accepted delay of not more than 1 to 2 days. Which would include the time taken for presentation of the charge sheet before the concerned court, and taking into account holidays, if any, in the intervening period. Next, but accordingly, the court taking an exception of the fact that in paragraph C of the affidavit in opposition, the respondent number 4 has stated that the IO had submitted charge sheet of the case on 30/6/2025, the court is inclined to call for an explanation by the respondent number 4 to sustain the statement made in the affidavit. In para 3 of the affidavit in opposition, that charge sheet of the case was submitted on 30/6/2025. Next para.
Remember the it was the sorry.
Few of the above, we direct the Commissioner of Police, Gauhati Police Commissionerate within bracket respondent number 3 to apprise the court as to whether there is any administrative instructions holding the field as to the timeline within which charge sheets prepared on a particular day should be positively submitted before the concerned court. Forwarded and forwarded to the concerned court. Forwarded to the concerned court. Post on. Next paragraph, the learned government advocate shall transmit a downloaded copy of this order to the respondent number 3 and 4. To respond to bring the order to the respective notice. Next paragraph, the affidavit by the respondent number 4 shall be filed on or before, give a date after 3 weeks. On or before so and so. No, 3 weeks, right? Make it 4 weeks. Yes, Republic Day. Sorry, Independence Day. No, second, we'll make it 25th of August. Special, there is no special bench, 25th August. Say. Okay, then 2nd September. 26. Yes, you were saying something, Mr. Bhattacharya?
The charge sheet was not available in the trial court, madam. We have applied, madam, on 8/4/2026. That's why, madam, there is an order of 10/5/26, 11/5/26, madam. Trial was given to my colleague, madam, to furnish the charge sheet, madam.
11/5.
Yes, madam, can you see, madam? We applied before the trial court, madam.
No, we understand because it's till 30, that is why we are issuing a notice.
Yes.
We have taken cognizance of that. That is why if it is held by the OC till 36,
Yes, ma'am.
we have issued this notice.
This is provided to commissioner. Finally, I can look.
Please pass it on. Please pass it on.
To the police commissioner. That might.
No. You see, you will show you why.
Yes.
No, we'll show you why. No, we'll show you from your own letter.
But in that letter.
No, we understand, but we'll show you your own letter. Into the city one. Take on maybe. 26.
I'm doing that for.
No, it's okay. We understand that. 36/25. We'll show you why. We are giving you this letter, which was an instruction produced by Mr. Sharma.
First one, madam.
Cannot be a mistake. And number two, if it is there, it is reckless. Number two, the charge sheet contains a type date of 25. Back date will never happen in police station. There is a reason for that. Because it should tally, and therefore there's a, you see, we forgot. We read so many things that we forgot in the meantime what we read. There are directions that after preparation of the charge sheet, it should reach the court within 15 days. But we are not sure of it because we forgot. There are administrative orders issued long back. So there's, you see, this can't be ipsit dixit of the officer that I prepare a charge sheet. So then what happens for whether it's manipulation? Supposing I am the IO, now I find that investigation has started. Departmental proceeding has started. Now what I will do is that I will write the charge sheet submitted in 2020. Can I do it now? That means there is no record that I will keep the charge sheet pending with me. If I'm OC, I'll keep pending with me for 6 years. Here this is 9 months. If 9 months can be excused, why not 6 years? So this calls for a departmental proceeding. They are not doing so right now without knowing that. That is why we have asked for this direction to the to this respondent number 3 to tell us what is the timeline within which it is to be submitted, because we forgot. We don't take up regularly this criminal bench, and therefore it's not very easy to remember everything. Just this is her instructions. Final charge sheet. It was a conscious decision of the respondent number 4 to tell this court that in 25 charge sheet was filed. Therefore, you see what happened is we could have taken a view that it is a clear case of interference with the administration of justice. The reason is, if that was not there, we could have issued a direction for a reinvestigation or a proper investigation, considered a CIT. Therefore, the respondent number 4 stopped us from doing it by giving information that in 25 we have issued charge sheet. We stopped there. We passed a judicial order and stopped there. Then Mr. Bhattakur comes and says that we have applied, we did not get it. Then this document comes into light when we have asked them to produce it. Then it comes to light that for 9 months the OC is withholding it. Why will he do it if he has no other interest? It can be possible that mistakes are purchased. It is possible. So we could have issued we told you that we could have issued a contempt notice. That is sufficient for us to take cognizance of that and issue a contempt notice, because this is clear case of interference with the administration of justice. So we are not very lenient when it comes to the interference with the administration of justice. We have a duty towards fair investigation and fair trial. That's one of the first duties of a court. And you will find this in Babubai, it is stated. It's a duty of the court to see that the investigation is carried out properly. Date. 24, then you don't get bail. Okay. Item 24, you take the comment. 21. Okay. How many motions are there? Item 19. Who is in item 19? Notice has already been issued. Just see item 19. TCR ISA, huh? Next week will be. You just say your positive time matter could not be taken up today. List on so. Item 20. Pardon me? What is this? For? Oh, so this is D voter. You got information? Day after tomorrow, we have some difficulty. It'll go to Wednesday. 5th August. Then 21.
21 मला to get it. Let it be posted on Monday, my lord.
They are not giving bail. Mr. Hindu Mandal for the petitioners, sponsor for the respondents. Opinion is at page.
Page my lord 80, my lord.
18. Dated 6/2/2024, passed by so and so and so and so. We are declaring the petitioner to be a foreigner post 1971. Notice, extra copies is introduced, call for the record. The prayer for bail shall be considered on receipt of the travelers reports. In the meantime, if the petitioner in this so and so is apprehended, she shall not be deported out of the country without order before. The petitioner shall cause production of a certified copy of the order before the Superior Police Border.
Dobry, madam. Dobry. Yes,
Dobry.
Dobry. Deep lotus.
Okay.